As we then turn to the substantive part of this conference, let me introduce you to Kiran Menon. He's a senior officer at the Nuremberg Principals Academy, and he will lead us to today's program. Kiran.
Thank you, Professor Safferling, and a warm good afternoon to everyone joining us here in Courtroom 600 and to our online audience. We will now have the opening discussion of the Nuremberg Forum 2025, titled Prevention and Justice 80 Years After Nuremberg. And I have the great privilege of introducing the moderator of this discussion, Ambassador Christian Much, who will be joined on the judges' bench by President Graciela Gatti Santana and Professor Juan Méndez. Mr. Much has had a distinguished 3-decade-long career with the German diplomatic service and served as Germany's ambassador to Libya from 2013 to 2016. He also served twice at the Permanent Mission of Germany to the United Nations in New York and chaired the Group of Friends to the International Criminal Court. Last but by no means least, in 2017, he was also the interim director of the International Nuremberg Principals Academy. With that, I would now like to hand over to the distinguished panel and ask them to join us on the judges' bench. Thank you.
Ladies and gentlemen, good afternoon. I will start a little different from what I had planned because I'm still impressed by the dire and almost apocalyptic words by which Director Christoph Safferling has described the state of international law, and this was in a way repeated by Mrs. von Uslar-Gleichen and by Silvia Fernandez. Of course, there's no way for us here on the panel to avoid these topics, and in fact we will discuss the same things where we stand, but also look at the achievements that have been possible in international criminal law. And we do that with the concurrence of two very eminent lawyers whom I would like to present to you. Mrs. Graciela Gatti Santana. She has been from the first day with the United Nations International Residual Mechanism for Criminal Tribunals, which is from 2012, and the president of this institution since 2022. She also looks back on 30 years in the judiciary of her home country, Uruguay, where she has also been the president of the magistrate, I think. And this function explains what contribution she has made to international criminal law, and the same is also true for Dr. Juan Méndez, who has been a fighter for human rights and for international law with his mind and with his body. With his mind as a lawyer first in his home country, Argentina, as a teacher right now at the American University in Washington, but several other universities in the United States mainly, but also in the United Kingdom. And I said also with his body because he had been a victim of torture during the Argentinian dictatorship, and so he knows what he's talking about. He also knew what he's talking about when he was made the special rapporteur on torture of the United Nations and the special advisor for the prevention of genocide. So welcome to these two members of the podium. And I think now I sit down because they are the main persons. May I start with you, Mrs. Gatti? I mentioned already your service at the residual mechanism. Your trial procedures have now been concluded, I think, 2 years ago. So the work that remains to be done is the wrap-up of the institution. And it would be interesting, not only for me, but I think for everybody here in the room, to know more exactly what is the residual function of the residual mechanism and what is the legacy of this institution, and by coincidence, by implication also the legacy of the Yugoslav Tribunal and of the Rwandan Tribunal.
Thank you very much. Thank you to the Nuremberg Academy for inviting me. It's a real honor for me to be here today. And thank you for the question, because as Ambassador Mark was saying, I'm the president of the Residual Mechanism for Criminal Tribunals. This institution was created in 2010 and started operations in 2012. And the mandate was to finish the work of the ICTY and the ICTR. So it was created as a residual institution, apparently, but it was not really a residual institution. It was a full active tribunal who had to do trials and appeals proceedings and review proceedings until 2023, when we pronounced the last appeal judgment in a case related to the former Yugoslavia. And the last case related to the Rwanda tribunal was stayed indefinitely because of health reasons of the accused person. So at that moment, in 2023, and then in 2024, when the prosecutor announced that he finished the tracking of all the fugitives that has to be found to be tried by the mechanism, because it was established that the ones who left were dead. At that point, we became a real residual institution. And then a new phase started, because justice doesn't finish when you pronounce the judgment. All of you are involved in justice, and you all know that after the judges pronounce the judgment, there's a whole world that starts after that. And it's enforcement, which is absolutely important, and other residual functions, which are also really important. So the mechanism now, it's working on these residual functions. It's working to continue to supervise the enforcement of sentences for 41 persons who are serving their sentences in different countries, in Africa and in Europe, and also making decisions in relation to early release, pardon, or commutation of sentences, and also conditions of detention. But we also have judicial activity, because there are still procedures, no trials, because the trials have finished, but we have procedures in relation to witness protection, access to confidential information, contempt of court. And for example, last year, we had a review proceeding, which was, I'm proud to say, kind of efficient and successful, because we were able to finish the whole trial, the whole process in just 1 week. And it was done in Arusha. It was a case related to a case of the ICTR. Also, the prosecutor is continuing his activity with assistance to national jurisdictions, not only in relation to witness protection, but also to help them, because, as you know, now that we finished, the work has not finished. There are still many pending cases in the former Yugoslavia, in Rwanda, and those cases have to start, and the sooner the better, because it's time for justice now. If we wait, that will be impossible. So Rwanda is very active. Bosnia is very active. It's not so active, but working on that as well. And many other countries, based on the principle of universal jurisdictions, with trials related to these conflicts, even if the conflicts are from the 90s. And the prosecutor is providing assistance for tracking fugitives, technical assistance, and also providing information that is contained in his evidence collection, which is the evidence that was not used already for the trials, because we have the data collection and all what was presented on the trials, but also there's a lot of information that he still has, and he's providing to the national authorities, of course, the ones who have jurisdictions on these cases, so that they can continue the work and to finish this accountability process. Also, we have the archives. We continue to administrate the archives. We have all the information and all the cases and all the evidence that was presented in our trials. So you were asking me about the legacy. And well, when I talk about the legacy, it's not only about the mechanism, of course. It's the mechanism plus the ICTY and the ICTR, because the mechanism is just a successor. It's a different way of doing the same work that these two ad hoc tribunals were doing. And of course, the first idea we have is, well, the judgments, to provide justice in these cases. But the legacy can also be understood in a broader way, because it's also preserving the information. The archives is a way of doing that, and that's why they have such a big importance now that the mechanism is getting closer to the finish of the work, although, as I said before, we still have a lot of work to do with so many people still serving sentences. But anyway, for some aspects, maybe we are getting closer, and the archives are a live way of showing what happened. It's the voice of the victims is there. Well, in our tribunals, in our trials, there was no possibility for the victims to participate as a party, but they were fundamental so that for the judges to be able to make a decision, and that is contained in the archives. It has an incredible value for the victims, for the states who were concerned, for the communities, and for the international community as a whole. So I would finish here if you want some more.
Yeah, if I may follow up with a question. The truth that is not only in your archives but also in the sentences, this is certainly a very, very important legacy of your tribunals, but of any tribunal. But I read that 2 weeks ago, one of the residual functions in relation to a prisoner was to release Yugoslav General Nebojša Pavković for humanitarian reasons, on the condition not to make any statement denying the crimes over which the ICTY had jurisdiction. I suppose there was a reason why you had to put this clause in the release order for Mr. Pavković. There seems to be a problem with accepting the truth. Can you explain why this happens?
Yes, and thank you for the question again. Yes, there's a reason for that, and it comes from some time ago, and it's because of the situation, particularly in the former Yugoslavia, and particularly in Bosnia, where the truth is not accepted in the same way in the different regions. Divisions are still there. So I was really shocked, for example, last year I went to a conference in Prijedor, and I could see a huge mural of Mr. Ratko Mladic, who's serving life imprisonment for crimes against humanity, war crimes, and genocide. And what it was written in the mural was "Hero Forever." So you can see that the acceptance of the truth of what happened, of what was proven beyond reasonable doubts in our courtrooms, it's not complete in some regions. So that's why it's so important for us, this clause, which is typical and normal in all the conditional early release decisions that we make and that were made by the former president, Judge Karmelagius, because at the beginning, the mechanism, when they released somebody, it was without conditions. And then we changed the practice direction in 2019, and conditions started to be imposed as a normal procedure to be sure that the release of a person who considers that convicted person will not have a negative impact in the community. Because, as I said before, international judgments, of course, they are important to establish the truth, they're important for the convicted persons, but they're important also for the victims, for the community, for the international community. And it happened before that persons who were granted early release based on, not like this case, which was based on humanitarian grounds, but based on rehabilitation, they convinced the judges at that time, the president at that time, that, well, they recognized the crimes, they acknowledged the importance of what they did, and that they were going to work for reconciliation. And then once they were released, they participated in interviews saying that everything was not true, that they just said that because they wanted to be released. So that had a terrible impact in relation to the credibility also of our work. So we think it's important to protect the work, and we think that is a possibility, that clause, that obligation is a possibility.
Dr. Méndez, to establish the truth for the sake of non-recurrence has also been at the core of your work with the United Nations. In both positions as a special rapporteur on torture and special advisor on the prevention of genocide. A very direct question. When you hear as a specialist on torture and somebody who has lived through torture, And you hear that states are trying to redefine torture, or that Russia is withdrawing from the European Convention on Torture. What is your reaction to that?
Well, first I want to thank the Nuremberg Principles Academy for this very kind invitation for me to participate in these proceedings. And I also want to congratulate you, Ambassador Moch, and the Nuremberg Principles Academy for this continuing effort to maintain and nurture the legacy of the Nuremberg trials. It's for me a very daunting task to participate, but it's also quite a distinction that I feel for having been invited. But in answer to your question, I believe, fortunately, that we have a very well established international legal framework for torture in the Convention Against Torture of the United Nations, plus some regional conventions as well, including optional protocols to establish the prevention of torture, that we should not ignore the need to prevent torture from happening in the first place. So I don't think that interpretations, in bad faith of what is and what is not torture really affects that international legal framework. That it's like all human endeavors, it's perfectible. It can be improved upon, but at least it's very clear now, and it's very clear not only what the elements of the definition are, but also the fact that international law establishes the absolute prohibition of torture and of cruel, inhuman, and degrading treatment or punishment, meaning that there's no circumstances that can allow it. And obviously, no circumstances that allow for bad faith redefinitions of torture. I also think that the international legal framework is very precise in establishing that the act of torture and of cruel, inhuman, and degrading treatment is a violation of a jus cogens norms, of a peremptory norm of international law, so that it applies even to states that have not signed and ratified the convention. Nothing can change that, even though these pronouncements that you mentioned do challenge us to make sure that we don't lose ground on the absolute condemnation by the international community of torture in all its forms, including both physical and psychological or mental torture. And that should encourage us to continue to fight for applying the definition of torture to things like solitary confinement, for example, that is used so widely, including increasingly widely around the world, as if it did not inflict the kind of pain and suffering of a mental nature that is conclusively part of the definition of torture. But I do appreciate the seriousness of the problem that you, Ambassador Moch, have just created, especially from the perspective of prevention of torture. Because by diluting the definition or by making it, or by refusing to, or the decision to denounce aspects of the international legal framework in order not to be bound by it, just makes the struggle for prevention of torture much more difficult. And quite frankly, and back to our problem, the prevention of torture is made difficult by the fact that we still don't insist enough on its investigation, prosecution, and punishment in all and every case. We don't insist as much on it, and that, you know, allows for governments and other state authorities to try to, you know, in bad faith, to come up with definitions that allow them to torture and to inflict a cruel, inhuman, and degrading treatment or punishment. And on the point of denial that Ms. Gatti just mentioned, I also think that that's a very important challenge to our efforts to prevent not only torture but mass atrocities generally from happening. This ability to rename things and change the nature of things and try to, you know, to create justifications for it is another way of denialism. And denialism both in the domestic legal jurisdictions but also at the international level is one of those serious challenges that bring us together here today and that we should all pledge to try to fight against.
Dr. Méndez, you were appointed Special Advisor for the Prevention of Genocide in 2004,
That's right.
10 years after the massacre in Rwanda and in the midst of other massacres or genocide in Darfur, if I'm not mistaken. The idea was that you would make educated recommendations to the Secretary General, who would pass them on to the Security Council, who would take unanimous decisions to prevent mass atrocities, slaughter, killing, and all that. Now, if we look at the reality, a lot of things have changed. Today, the Security Council does not take measures to avoid such massacres. It's rather the International Court of Justice, and that has to come up with preventive measures to limit the genocide. And at the same time, there was also another special advisor on the responsibility to protect, who suffered a little bit the same fate, that his recommendations were never taken, or not never, but rarely taken very seriously or led to any action. We live in a world now, and we heard that at the beginning, where the international order is in deep trouble, and the Secretary General, in his opening speech at the General Assembly, had to say words like, what kind of world will we choose? A world of raw power or a world of laws? He said that for a reason, and it sounded very much like words of despair. What has changed since 1994 and now?
Well, unfortunately, I have to have a pessimistic note to my response. I think in 2004, the international community was still convinced that there were measures and means by which the Charter allowed organs of the United Nations to display effective means of preventing atrocities from getting out of hand and become mass atrocities or even genocide. But even then, quite frankly, what we really had behind the creation of these two special advisorships was the commitment and dedication of Secretary General Kofi Annan to this task. He made it a personal, mission to establish these things, and I do think it is part of his legacy precisely that those two advisorships even exist today. But even in those first years, I went twice to Darfur and I briefed the Security Council twice. The first one about Darfur, but the second one was just a general briefing to, representations of the Security Council at secondary or even tertiary level, and it was just about the plans for the office. And in all those 3 years, I tried unsuccessfully, unfortunately, to have the Security Council take a more hands-on approach. However, as that was happening, the 2005 summit did come up with an attempt at reform of the United Nations that in many parts was unsuccessful, but in some did create some very good steps forward, like the creation of a year-round Human Rights Council and the creation of the Peace Building Commission, that is a way also of acknowledging the negative effects of allowing mass atrocities and an armed conflict to happen. But for me, the most salient result of the summit outcome document of 2005 are those paragraphs 138 and 139 that describe this doctrine that we call responsibility to protect. I can attest to the fact that it was quite an advancement to be able to quote a summit that had been attended by more than 100 heads of states and governments to say these are the steps that have to be taken in order to protect population at risk from mass atrocities. And that summit outcome document was approved unanimously without any objection, was also a validation of both the creation of the Office of the Special Advisor on the Prevention of Genocide, but also later of the creation of the Office of the Special Advisor on Responsibility to Protect. Unfortunately, there were later, over the years, 3 or 4 discussions at the General Assembly of Responsibility to Protect, and all of the discussions ended up, one with a very consistent majority, 75 or 80% of the countries participating, reaffirming the doctrine of responsibility to protect. But the final resolution was always to keep discussing this and not doing much more than that. And in the meantime, however, the Security Council, for one reason or another, has been reluctant, to say the least, but sometimes firmly opposed to bringing up situations of mass atrocities that should have been the reason to invoke both the responsibility to protect and the creation of the Special Advisorship on Prevention of Genocide. In fact, I think that aspect has continued to undermine the original ideas of 2004 and 2005, and made these efforts now sound like relatively benign, but not all that effective means of preventing mass atrocities. I do think, however, that the responsibility to protect continues to inform the way the Secretariat organizes its work around the world, and it continues to generate an attitude by the men and women of the United Nations around the world on what to look for and what to suggest. And it does contribute to what I think is important here, that even if the Security Council doesn't want to hear it, it's still important to provide early warning and come up with good ideas for early action to alter the course of events, so that early warning does not become a reason to mourn acts of genocide. I think we are not in we're not in the same place as we were in 2004. We are backwards from 2004, but we should not forget what has been achieved, including the fact that there are special advisors at the Secretariat on the prevention of mass atrocities and genocide and on responsibility to protect. We should give them more visibility and more support, but they are there and they are an achievement.
We should not ignore what has been achieved. I agree with you and probably Ms. Gatti as well. Yet you would probably also agree that the commitment that existed in 1994 or in 2004, the commitment of states is not the same anymore. And maybe we can ask ourselves why, what happened? Were there maybe too many cases where breaking the international law had no consequences for the perpetrators? Or were the assumptions on which a multilateral legal order was built, which is that we have the mechanisms that agree on the basis of mutually agreed rules how to contain warfare, atrocities, etc. Were these maybe fair weather assumptions that did simply not stand the test of time? What exactly happened? I don't know who wants to answer the question.
Okay, thank you. Well, at the risk of sounding like I'm looking for some sunshine in between a very clouded sky, I also think we should bear in mind that sometimes it did work. Sometimes what is said in the preamble to the Rome Statute, that we create this tribunal in order to discourage and prevent genocide, crimes against humanity, and war crimes, and the crime of aggression from happening, at times has helped. I remember, for example, that first in Côte d'Ivoire, there was a moment during several years of very tense confrontation with the country divided geographically, but also with militias roaming both cities and countryside. There was one moment in which the National Television and Radio Authority had been replaced, and the new authority called on these militias to attack all the non-Ivoirians, as they called the minorities that they were against in Côte d'Ivoire. And at that point, both the Secretary General, but also others, including myself as a special advisor on prevention of genocide, made statements to the effect that those who spread ideas and orders that could be considered instigation to commit genocide could see themselves brought before the ICC, because Côte d'Ivoire at the time had acceded to the Rome Statute. And I learned later, at that time, there was complete silence, but for some reason the roaming by militias stopped within a weekend. It wasn't longer than that. And we heard that lawyers for Mr. Gbagbo actually were consulted, and they looked at their notes and treaties and commitments of the Ivorian state, and they said, yeah, maybe it's true. Maybe we'll all see ourselves sent to The Hague. And that seems to me, people who were there at the, including members of the international community representing their own countries in Côte d'Ivoire, attest to the fact that the threat of providing justice, including for instigation to commit atrocities, did have some effect in that. I also think that there have been moments in which when the ad hoc tribunal started prosecuting people for recruiting children. Some non-state actors started worrying that because they recruited children also, they might be brought before justice. This is anecdotal, and I wish I could say it is a good sign that these things work. But at least if we're going to bear in mind that many of our efforts have failed or have not been as successful as we would want them to be, we should also, for the purpose of reminding ourselves that the struggle is difficult and it's long, but it has to be undertaken, then draw inspiration for that purpose from those, kind of anecdotal moments in which these efforts, including the creation of the ICC, did have some effect on the ground.
Mrs. Gatti, would you agree with what Dr. Méndez just said, which is that arrest warrants or the danger of running into an arrest warrant could change the attitude of players in a conflict, reputational damage or the danger of being arrested, from your perspective?
Thank you. Yes, I will have a kind of positive view about this, and I agree with what Professor Méndez said in general terms, because it's incredible. If we look behind, if we look at the moment of the Nuremberg trials and everything, all the things that happened until now, we can see that international justice is a process that has very incredible landmarks that were not considered possible some decades ago, and that cannot be erased. It's in the common principle for the international community, I guess, at this point. In 1983, when the ICTY was created during the conflict in the former Yugoslavia, not too many people believed that it could fulfill its mandate and it could succeed. And of course, there's no perfect institutions, but I think it was a successful story, the one of the ICTY. It was able to take to trial the most responsible for atrocity crimes committed in the region. It indicted 161 persons and conducted fair trials to do so. So I think it was a story of success of the international community. The same, the ICTR. The creation of the ICC, what an very important landmark in the history, having an international criminal court, a permanent criminal court, who is active today. Yes, maybe international order is in deep trouble, as you say, but it's still continuing the work that was started before. Now, nobody can doubt that a head of state can be put on trial. And at the beginning, who could have thought that Mr. Milosevic would be indicted in the 90s? Then James Taylor was put in trial by the Special Tribunal for Sierra Leone. Now we have two heads of states who have arrest warrants. I'm not sure if these arrest warrants will have, and I'm sure they are not going to have an immediate effect to stop the conflicts, but there will be consequences, because it's not only the process, it's the risk of it, it's also how it will impact at one point the internal politics in the respective countries, and it will have an impact. It's very difficult to measure because we cannot compare to what would have happened if those arrest warrants wouldn't have existed. But they are there, they're important. Nobody can say now that we don't know the consequences. A head of state cannot say it, and what Professor Méndez was saying is a clear example. We all know now the law was developed in a way that we know everybody knows what they can do and what not. And I think it has an important deterrent effect. And also, it brings a certain hope to the victims. And that's not something we must not consider. It's important for them. They know that at one point, justice will come. Of course, there are other tools that we can use at this moment when international justice cannot proceed to trial because there are obstacles for that and challenges. Well, investigative mechanisms that keep and protect the evidence can be useful. Reparations can be also useful tools to provide a certain degree of justice. So I think, yes, I think there's no possible sustainable peace without justice. Justice is not enough. You need also the work of the whole community, you need other components. But without justice, without knowing what happened, without knowing the truth, it's impossible to have a real reconciliation process anywhere. So I think they have an important effect, even under special trouble or deep trouble, as you said,
that
was
encouraging to hear, and I would like to come back a little later to your point about justice working hand in hand in a, let's say, interdisciplinary way with other aspects like reparations, reconciliation, etc. But still, let me play the devil's advocate a little longer. I would agree with you that from 1945 to the maximum number of ICC ratifications, something over 130, I think, I don't know the number exactly, that there the wave was definitely moving to its crest. Now I think we are going down from the crest again to a certain low. And to put my question bluntly to both of you, what is the role of international law in a world where out of the 4 major powers in the world, 3 have a very disturbed relationship with international law?
I can't provide a political insight for this. You can understand me, I'm a judge, so I will try to keep it on the legal ground.
But maybe you can look at it from a tribunal's perspective. From a tribunal's perspective, that means how much do states cooperate with you?
Of course, it creates big challenges because international justice needs state cooperation. International justice is absolutely based on state cooperation in a certain point because you need it not only for budget, but also because to enforce your decisions, you need cooperation of states. And when states, and the most powerful states, don't cooperate, you can imagine all the troubles you have. But even not going in such big situations, also for the day-to-day decisions you have to make for a tribunal like mine, who is not in the middle of the most polemic situations at this moment, even now we continue to need state cooperation. And the problem is there when the international community is not ready to commit. Because justice is not only a matter for the tribunals. It's for the whole international community. They have to work hand in hand. And it's terrible when you see, and let me say this, maybe it's too much, but I cannot say, it's terrible when you see a country which is a member of the ICC and one person who has an arrest warrant by the ICC is received in that country. That's something, that's something we cannot accept. That is terrible, and that's a big challenge for that court and for all the international system.
That is a problem of hypocrisy, isn't it?
Well, yes, sometimes double standards or just international justice is important and we believe in it when it doesn't affect our interests. That's a position that some states take.
Dr. Méndez, what do you make out of the situation where 3 out of 4 big powers have a difficult relationship with international law?
Well, I think that others are more qualified than myself to, give a whole answer to why the Security Council isn't living up to the promise of the Charter of the United Nations. But I think, I'm not being heretic in saying that it's not living up to the challenge. There are so many very serious, threats of mass atrocity that don't even get discussed at the Security Council. And I think, obviously, it's the veto power that the 5 permanent members hold, which probably accounts, at least institutionally or normatively, if you will, for the paralysis that the Security Council engages in most of these most difficult situations. And unfortunately, even because of the competition between some of those members of the Permanent 5 for influence and for policy and for domination even, that also allows for a sort of checks and balances of in the most negative possible sense of the possibilities of the Security Council doing its job. I think, in fact, the fact that we do have a charter that allows for this only means that we need to continue to encourage the Security Council to take its job seriously. And that means, obviously, as Judge Gatti was saying, it's not just the job of courts and prosecutors, but it's also the job of communities and civil society groups everywhere, and of states, and of the international bureaucracy to bring these matters to the attention of the Security Council and confront the Security Council with its failure to act. But I also want to say that even as we speak, the legacy of Nuremberg and the legacy of the 90s and 2000s with the creation of the ad hoc tribunals and then of the Rome Statute has also inspired and continues to inspire domestic jurisdictions to do the right thing. And we should always bear in mind that we're not talking about substituting for domestic jurisdictions. The mass atrocities have to be confronted by the domestic jurisdiction, by universal jurisdiction when that fails, and under the principle of complementarity by the International Court, Criminal Court. And as you said earlier, also by the International Court of Justice that finally is taking action on some cases dealing with gross human rights violations, including genocide. I mean, for years it was not in the docket of the International Court of Justice. Now it is. Is it going to have all the effect that we want? Well, it depends on us. No, it doesn't depend only on the International Court of Justice. But we have this framework and these institutions, and we need to use them more. And I completely agree also that justice is central and essential to the prevention of mass atrocities. But it is not sufficient. It's not by itself capable of doing this. And I think we need to, on the ground, to provide for investigation and gathering of evidence so that we can, at least at some point, prosecute some of the worst offenders. But we also need to work on protection of the populations at risk, even physical and even military or police protection, if necessary, by the international community. We need to provide for humanitarian assistance because people who are at risk of many things, not just of murder, not just of starvation, but many different things. And because both accountability for the crimes that are already committed and humanitarian assistance can give agency to the victims themselves, can allow them to participate in designing their own future and to participate in the prevention of crimes against them. We also need to continue diplomacy. We need to insist on peace processes. And they're always messy and unsatisfactory, but they do offer an opportunity. And I think definitely, I mean, those 4 steps, working together and in coordination, are essential to prevention of mass atrocities. But I think it's important that justice has to be taken for its own sake, for its own value, and then it also has to be impartial and independent and provide for fair trials because it has to be legitimate and seen to be legitimate. And finally, it being impartial and independent means that it doesn't apply only to poor countries. It doesn't apply only to perpetrators of abuses that are not powerful in the international community. It has to be applied across the board under the specific circumstances and with the appropriate evidence. And if it does that, then in addition to gaining legitimacy for itself, then justice contributes to peace and to prevention. in coordination with these other steps that need to be taken.
Yeah, you mentioned the International Court of Justice. The International Court of Justice was the one institution that decreed provisional measures against mass atrocities in Gaza. It was not the Security Council. That would make your point that justice is now in good hands with the International Court of Justice, but it also means that sort of the guardian of a rules-based international order is not anymore the Security Council as it used to be in the past. Do we maybe have to look for such safe havens where a rules-based international order can survive not only the ICJ, but maybe also success stories at regional or local level, for instance here in Europe or in Latin America?
Well, I think as I said, the fact that the International Court of Justice has seen it fit to issue provisional measures, interim measures, is a very welcome legal development, especially because since the advisory opinion on reservations to the Genocide Convention, there were literally 3 or 4 decades in which there was no case brought to the attention of the International Court of Justice. But I don't think it should relieve the Security Council from its own obligations. Among other things because we still have the problem of compliance with the interim measures. And if states find a way of saying, well, I don't care what the courts say, then we're back to square one. And of course, they can also say, we don't care what the Security Council says, but the Security Council at least has, under Chapter 7, the ability of mobilize international force. The only use of force other than self-defense that is authorized in international law. And I think that's an important aspect of prevention that we should not lose sight of.
One final question to both of you, because time is running out. You both come from countries that have lived through a dictatorship. Neighborhood, yes. Military dictatorship, and both countries have come out of it as well. Maybe in different forms, but certainly in a way, as you indicated, where measures of justice and other measures have played together to stabilize the newborn freedom and justice. Can you briefly tell us about the experiences that you have made in this regard in both of your countries?
Well, yes, and this is like a follow-up of what Professor Méndez was saying, because, of course, we cannot say, well, the Security Council is not doing as much as it should, let's forget it. No, it has to do what it has to do. But when the Security Council cannot do it, or is not for it to do something, we cannot disregard the power of national justice or regional justice. We can also be a very important tool in terms of peace and keeping the peace for a long term. The processes in our countries were not exactly the same, although we all, Argentina and Uruguay, had military dictatorships in the 70s. I'm not going to talk about Argentina, that will be for you to do. In Uruguay, we had the clear example of how necessary justice is. Why? Because when democracy came back in 1985, the decision of the government and the population who voted for that government was, let's forget everything. Let's pardon everybody so we don't have any problems, and we guarantee that this new government will succeed and the militaries are not going to threaten it again, because they were still kind of powerful in Uruguay. They left the power, but they kept some power. So there was some concern about the possibility of the military to return in power. So that was the decision, and that proven to be a very wrong decision, because we struggled during more or less 20 years with this decision, not having the possibility of investigate, because we had a law that said that there was no military that could be investigated for crimes committed during the dictatorship. So that was really terrible. Finally, the society mobilized, civil society mobilized, those laws were left aside, and now we have trials. We started in the 90s with trials. But that proves how, of course, I can say now that we live in a complete democracy, and I think everybody is convinced that the never again of what happened with the dictatorship must be a reality, but justice was absolutely necessary. Although, of course, in a society you have different points of view, I think Uruguay is a good example of how you cannot try to hide things. You need to know the truth. You need to let the victims speak. People need to understand what happened if you want to heal that society.
I think central to this embracement of democracy that has happened in the Southern Cone, particularly in Argentina, that now has lived for its longest period of its history with elected governments, almost five decades already, half a century. And the central aspect of it is that the community of Argentina has taken to heart the never again kind of dogma. And in the case of Argentina, it reflects the support for the trials that continue to exist today for violations committed during the military dictatorship. And so, in fact, when governments of different ideologies or political identification succeeded each other, that embrace of justice through prosecutions, through reparations, through truth-telling, and through measures of non-repetition, including memory, preserving memory, has become a sort of state policy. That, of course, it has its detractors, it has its enemies, but the population as a whole continues to insist that these processes have to continue. And I think, God knows Argentina has lived through financial, economic, social crises in these 50 years that in other times would have meant that we'd have a military coup to take over and clean up the act, so to speak, as they pretended they were doing. But through those crises, this question of the trials that started with the trials of the junta members themselves, but continued then later, have sustained the democratic process. And I want to insist, I think I said it, but I'll say it again, the decisions, the judicial decisions that declared unconstitutional the legal obstacles to these prosecutions were all inspired by Nuremberg and by the Statute of Rome, and in our Western Hemisphere region by the jurisprudence of the Inter-American Court of Human Rights that has now repeatedly said that there are some crimes that are so egregious that the state cannot afford to let them go unpunished.
Thank you. I think that was an inspiring vision for the future. That if crimes are too bad, then simply there's no way around addressing them, as you just said. Unless you want to make a final sentence, we would have to stop soon. I think we agree that you have the opportunity for a final word, so please go ahead.
You want to say? Well, not very short, just to acknowledge that indeed international justice is under pressure, it's in deep trouble. We heard the opening remarks. I agree with everything that was said, but we cannot ignore what was done since Nuremberg to today. This is something that it's such a big achievement for the international community. And I don't think, maybe I'm a bit naive or too much optimistic, but I don't think that this terrible moment will be able to destroy everything that was done. Some principles are so clearly established, like what is a genocide? A head of state can be in trial. There's responsibility, the importance of justice for reconciliation and peace processes. So I think, yes, now it's difficult moments, but I'm sure, and this is an example, look at this place full of people who want to protect international justice. Working together, the international community, finding other ways, if it's not possible at the international level, at the national level, other mechanisms that can be created, preserving evidence for better times, that those are all possibilities, and I'm sure at the end, justice will prevail.
Thank you very much. Juan, another word?